key legal issues and best practices surrounding food recalls in both the United States and Canada. More and more of the recalls that we're seeing involve food that has been distributed across borders, making it critical to understand how to effectively and efficiently implement recalls in multiple countries. Today, we plan to provide a brief overview of U.S. and Canadian regulatory structures, an examination of current trends and increases of food recalls by the FDA and the CFIA, best practices preventing and identifying risks before they happen, and rapid response, disaster plans, and a how-to guide and checklist for companies dealing with food recalls. We have a number of great speakers with us today from Foley and Miller Thomson. Our Foley speakers are Nate Beaver and David Rosen. Nate is a partner with Foley and a member of our firm's government and public policy and FDA practices and the food and beverage industry and life science industry teams. Nate's practice focuses on the representation of companies whose products and activities are regulated by the FDA, DEA, and the Federal Trade Commission. He advises clients on regulatory issues affecting prescription and over-the-counter drug products, including animal drugs, medical devices, dietary supplements, cosmetics, and foods. David Rosen is a partner with Foley and co-chairs our life science industry team. He's also a member of our food industry team, our government and public policy practice, and our healthcare team. David, who spent 14 years with the Food and Drug Administration, has extensive experience counseling clients on FDA and related regulatory issues affecting food, prescription, and over-the-counter pharmaceuticals, medical devices, and biologics. Now let me turn things over to my co-moderator, Brian Khalil of Miller Thomson, to introduce our speakers from Miller Thomson.
Good morning. This is Brian Khalil from a snowy and cold Edmonton, Alberta. I'm a partner with Miller Thomson. I'm also the co-founder of Miller Thomson's Agriculture and Food Production Practice Group. We are very pleased to join Foley Lardner in this presentation. For our American listeners, I should indicate that Miller Thomson has 11 offices in 5 provinces across Canada, from Vancouver in the west to Montreal in the east. Now for the presenters. Our first presenter, Catherine Bate, has kindly agreed to step in at the last minute due to the inability of Jennifer Bishop to make her presentation. Jennifer holds degrees from the University of Toronto in law. She's been practicing law since 2002. Her specialty is in marketing and advertising. Catherine is a member of both the Canadian and the American Bar Associations. Her impressive credentials include peer recognition as Lawyer of the Year for Toronto in 2012 in the marketing and advertising field, and one of the 5 best lawyers in this field in Canada, according to the Lexpert American Law Guide for the last 3 years. Robert Anderson has been practicing law at Edmonton, Alberta since 1984, just a decade after I started practicing in the 1970s. I have known Bob since then. His practice focuses on agriculture and food production, corporate and commercial law, and banking and financial services. Bob has also worked in-house as in-house counsel for a number of large firms in the food production area. Catherine's talk will be will be aimed at providing an overview of Canadian law and in this area. Bob will share some of his experiences in the recall area. Thank you very much, and I'll turn this back to Mike.
Thanks, Brian. Before we start, I just want to mention a few housekeeping tips. A copy of the slides can be found in the materials section of your screen. Questions can be submitted electronically during the web conference by using the Q&A tab. And Foley will apply for 1.5 general CLE credits for today's program. Please note that all New York, New Jersey, and Kansas attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code that will be announced, actually 2 of them, at some point during the webcast. And the attorney affirmation form in today's slides, again, can be obtained in the materials section on your screen. Now, I'm pleased to turn the program over to our first speaker, Nate Beaver.
Thanks, Mike, and thanks, Brian. As Mike said, my name is Nate Beaver. I'm a partner in our Washington, D.C. office. So good morning and good afternoon to everyone. I'm going to be talking about the regulatory requirements for recalls and some of the nuts and bolts of recalls. And then my colleague David Rosen will be talking about preparation as well as some additional advice on dealing with recalls. So historically in the U.S., all FDA recalls were voluntary until relatively recently. FDA did not have authority to order a recall in the past, though it could pursue other avenues of enforcement, such as seizure or injunction, as well as public opinion as well. However, since the passage of the Food Safety Modernization Act in 2001, FDA now has mandatory recall authority that I'll talk about in a moment. However, it remains very limited in its usage, and the vast majority of recalls continue to be conducted voluntarily. Let's start with an overview of the Food Safety Modernization Act of the statute with respect to FDA's mandatory recall authority. The statute outlines what requirements must be met in order for FDA to pursue a mandatory recall, where it says there must be a reasonable probability that a food is either adulterated or misbranded, and that its use or exposure will cause serious adverse health consequences or death to either humans or animals. In an instance where FDA believes that standard is met, it must provide an opportunity to the company first to recall. And if the party does not do so, FDA, within the time and manner prescribed by FDA, may order a recall. Before issuing the order, FDA must again first provide the party with an opportunity to cease distribution and conduct a voluntary recall. If they refuse, FDA must first offer the party informal hearing within 2 days of the order being sent to the company. Now, there are both civil monetary penalties for noncompliance, as well as FDA does have authority to charge fees in the event that it undertakes a mandatory recall. Keep in mind that FDA's statutory authority is now effective upon passage of the Act, so it's been since 2011 that FDA has been able to order a mandatory recall here in the U.S. To date, though, FDA has initiated only a single mandatory recall action. The first and only was in February of last year in an action against Castle Associates Industries for a product involving pet treats that had tested positive for salmonella. In this situation, Castle had actually initiated several recalls of the product already, but FDA had pushed for to expand the scope of the recall, and at least initially the company had pushed back about that. However, after FDA issued an order indicating that they were prepared to go forward with a mandatory recall, ultimately Castle initiated a voluntary recall and thus expanding the scope of the recall with this particular pet treat. Now, even without mandatory recall authority, FDA has significant leverage, obviously. They certainly use the leverage here, but in other ways, such as press releases and the power of the press, FDA certainly has always had many tools in their toolbox to convince companies that a voluntary recall is the best approach. FDA has certainly stated that it will use its mandatory authority relatively infrequently, and the data reflects this. That in the 3 years since they've had such authority, there's only been one proposed mandatory recall. Let me give start by giving the definition, the regulatory definition of what a recall is. FDA defines a recall as a firm's removal or correction of a marketed product that FDA considers to be in violation of the laws it administers and against which the agency would consider initiating a legal action, such as seizure of the product. With that in mind, let's talk about when an action is not a recall. And there are two types of actions that are not considered recalls. The first is market withdrawals, which is a removal or correction of a distributed product which involves a minor violation that would not be subject to legal action by FDA or which involves no violation at all. For example, normal stock rotation practice, routine equipment adjustments and repairs, and perhaps very minor labeling violations, for example. A stock recovery is a removal or correction of a product that has not been marketed or that has not left the direct control of the firm. For instance, the product is located on premises owned by or under the control of the firm, and no portion of the lot has been released for sale or use. In either of these instances, if product is pulled, this is not considered a recall under FDA's definitions. So voluntary recalls again. Now, FDA has had voluntary recall guidelines in place for some time. They can be found at 21 CFR Part 7. FDA's guidelines on having a recall plan in place suggests that companies should be able to answer three basic questions anytime the potential for a recall is present. First, what is the affected product? Second, what is wrong with the product? And third, where is the product located? Notifying FDA. Companies are requested, and of course keep in mind that, again, these are voluntary recalls, but companies are requested to notify FDA of a recall by contacting its local district office immediately. And you'll see the link underneath my slides provides the link to FDA's recall coordinators for each district. Now, again, this is not mandatory. It's not legally required that FDA be notified in the event of a recall, but typically notifying FDA will be the best approach. However, in those instances where a company decides not to approach FDA and notify them of a recall, there is, of course, the possibility that FDA will later learn of the action, for example, during an inspection of the facility. And there is the possibility that FDA may disagree with the action taken or the manner in which the recall was undertaken. Now, assuming FDA is notified, FDA will request information on the recall. And typically that first call to the recall coordinator is obviously an opportunity to make a good first impression. My experience in dealing with those initial calls to FDA recall coordinators is that obviously a lot depends on what the potential hazard is. And when it's a microbial contamination that could cause serious adverse events or death to someone, especially if the scope of that particular product is large, FDA may take a very keen interest in how the recall is being conducted and want to be very involved. But I've been involved in other situations where recall is conducted, where after that initial call with FDA, if you can make a good first impression, if the recall coordinator has a good sense that the recall is going to be conducted in a reasonable and efficient manner, it may be that the FDA's role is very hands-off in a particular recall. So again, you always want to be able to give FDA that initial confidence that you know what you're doing. The FDA submission will typically include, once you're making a written submission to FDA, obviously the identity of the product involved, the reason for the removal or correction, and the date and circumstances under which the product issue was discovered, an evaluation of the safety risk associated with the issue, the total amount of product that was produced, as well as the time span of the production, which of course will give you some indication of what the scope involved is. the total amount of the product that is estimated to be in distribution channels, as well as product that you may still have under your control. Distribution information, including the direct accounts and where necessary, FDA may want the identity of the direct accounts. A copy of the firm's recall communication, or in many instances, a proposed communication. And there certainly have been instances where, for example, we've prepared a proposed press release and permitted FDA to review that press release. They may have comments and questions. There have been instances where it has been useful for FDA to review that, and they've made helpful comments. I think looking at FDA as a partner in these types of situations can typically be very helpful. The proposed strategy for conducting the recall, and then of course the name and telephone number of the contact person that FDA can follow up with as needed. Part of FDA's role in the recall is making a recall classification. Although typically companies will provide FDA of what they believe the correct recall classification should be, ultimately this is a determination that FDA will make when they classify the recall, which of course recalls are listed on FDA's website under their enforcement reports, and it will indicate what FDA considers the classification to be. And based on the submission, FDA generally determines a Class 1 recall is a situation where there is a reasonable probability that the use of or exposure to the product will cause either serious adverse health consequences or even potentially death. And typical examples of Class 1 recalls are allergen recalls, for example, where an allergen is not appropriately labeled, and certainly microbiological contaminations such as E. coli and Salmonella. A Class 2 recall is a situation in which use of or exposure to a product may cause temporary or medically reversible adverse health consequences, or where the probability of serious adverse health consequences is remote. And examples of typical Class 2 recalls would be perhaps foreign objects in the food, or very low levels of pesticides where safety issues are not a concern. Finally, Class 3 recalls is a situation in which the use of or exposure to the product is not likely to cause adverse health consequences. And examples might be minor label violations where allergens are not an issue. Another issue, of course, to be addressed is the depth of recall. Will this recall go to the wholesale level, retail level, or consumer level? And generally, it depends on a number of factors, but certainly including the degree of hazard, what's the real safety risk here, and part of that is how FDA determines the classification level, but also the exposure of the product and the extent of the distribution. All of those are going to have an impact on ultimately what depth is chosen here. A recall strategy and proposal should include the depth of recall, and again, this is another area where a proposal can be made as well as an explanation of why you believe the depth of the recall should go to a particular level. And it may be an area where negotiation with FDA is possible, again, explaining the reasons that you think a particular depth of recall is most appropriate here. Press release and public statement are also necessary, are often necessary. And again, these are documents that it can be useful to prepare in advance to permit FDA to be able to review them to see how you're planning on handling the issues and see if FDA has any particular input. Effectiveness checks are obviously going to be needed. Effectiveness checks verify that co-signees have received notification about the recall and taken appropriate action. It may be follow-up by phone, email, or fax. And of course, documentation is always necessary here. Now, the percentage of effectiveness checks that FDA may require can vary, but it's certainly not unusual for FDA to want 100% effectiveness checks. But again, this is an area that may be negotiated as well. And I have had instances where, again, a proposal can be made to have less than 100%. And if that's followed by rational and reasonable explanation, there have been instances where we've been able to convince FDA that 100% either wasn't feasible or was not needed. Periodic status reports will be needed submitted to the district office, and generally those are submitted every 2 to 4 weeks. They should include status information including the following: the number of co-signees who were notified of the recall and the date and method of the notification, the number of co-signees responding to the recall communication and the quantity of products that they had on hand, the number of co-signees that did not respond as well, the number of products returned or corrected by each co-signee, the number and results of effectiveness checks that were made, and then the estimated time frames for completion of the recall. Termination of a recall. Status reports will continue until a termination of recall is completed, and generally when a firm thinks that they have reached what they believe the termination state of a recall, a status report will be submitted, which includes information indicating that they believe a recall should be terminated. FDA's regulations on termination say that FDA will determine a recall to be terminated when all reasonable efforts have been made to remove or correct the product in accordance with the recall strategy, and when it's reasonable to assume that the product subject to the recall has been removed or proper disposition of the product has been made commensurate with the degree of hazard of the recall product. And I think the important aspect of there is commensurate with the degree of hazard. So to some extent, this is a sliding scale as to when is a termination can be considered complete. This may be done informally, and as I said, status reports are often submitted by email these days, and it may be simply receive an email from FDA that's relatively informal saying that they believe the recall to be terminated at this point. Or it may be that a company may request termination of recall in writing. And again, this is going to depend on the scope and status of the recall as to whether a more formal or less formal route is taken in terms of termination of the recall. Now this is a sort of a related issue, but a question that should always be asked when a recall may be a possibility is the recall reportable? Under the Food and Drug Administration Amendments Act of 2007, FDA was required to establish the Reportable Food Registry. The Reportable Food Registry applies to all FDA-regulated categories of food and feed, except dietary supplements and infant formula. So facilities that manufacture, process, pack, or hold food for human or animal consumption in the U.S. are required to report when there is a, quote, reasonable probability that the use of or exposure to an article of food will cause serious adverse health consequences or death. Now, the language that I have highlighted in red there may be familiar if you remember our Class 1 recall standard, and essentially the language is almost identical here in terms of if a recall meets the definition of a Class 1 recall, it's likely that that recall will also be reportable. And note this is applicable both to humans or animals' food as well. In such an instance, when there is considered a reportable food, a responsible party must submit the report. Now, not all recalls are reportable, but for those that are required to be submitted, FDA wants the submission to be as soon as possible after determining that an article of food is a reportable food, but in any instance not less than within 24 hours after that determination is made. You'll see I've got a link there to the Reportable Food Registry. It is all done online and can be done essentially 24 hours a day. The most common reported events to the Reportable Food Registry are for things that show up most often as Class 1 recalls, not surprisingly. Things like undeclared allergens, salmonella, and listeria as well. Now it's important to know as well that there are instances where a reportable food may not need to requirement to report. And this is if there's been adulteration which originated with the responsible party, it's not okay. And finally, where the product can be either corrected or destroyed. So in instances where it's still under your control, it originated with the responsible party and it can be corrected, that's not required to be submitted to the reportable food registry. All right, having touched on that, I'm going to now kick it over to my colleague, David Rosen. Thanks, David.
Thank you, Nate. Thank you. Thank you for that nice summary of what the requirements are for recalling food products, as well as what needs to be reported and what doesn't need to be reported under the Federal Food, Drug, Cosmetic Act. Now, we all work hard to ensure that our products meet appropriate standards and specifications and tests, both in process and finished product controls. Unfortunately, recalls occur, and so this part of the talk is going to be, getting prepared for that the recall event should it occur. And you can see from the current trends, we see a fair number of recalls that have gone on over the last years. And so we try to do everything that we can to prevent them, but they still do happen, and so we really want to be prepared when they do occur. Why does, getting things right matter? What's so important about this? We've had, significant issues with respect to peanuts and peanut butters and things of that sort. One of the, a very highly recalled class of foods because of salmonella contamination routinely occurs in peanuts and peanut butter and things of that sort, and it's just widely used. And it does impact a significant number of products as well as many companies. And so it had a significant impact on the company as well as the executives of that company too. We tend to hear about the ones that make a big splash in the news too. We had issues with cantaloupes, for example, in 2011. Again, listeria contamination, very significant. And you see the impact of the recalls on the company and the amount of sales volume that has dropped in a very short period of time can have a catastrophic impact on the companies. Again, we've seen nuts again and contamination with salmonella, and they've had their registration suspended, and the facility and the industry is still trying to recover from these types of things. So hopefully we can prevent them. Hopefully we have controls in place to prevent these things from occurring, and we test to make sure that there isn't a problem, but they do happen. So is it worthwhile getting recall insurance? That's a question that people need to ask. Is that, can we shoulder that burden ourselves? Are we willing to do that, or do we need to reach out to third-party insurance companies? And I suggest that people might want to contact their insurance companies to see how much it costs, what are the events that are covered, and things like that. What's the deductible, and what is the likelihood of having an insured event, depending on the nature of the product that you're producing or distributing, and whether or not, if there were to be a recall, is that something that the company may be able to recover from, or whether or not it would be likely a catastrophic event, to say the least. So, there's a lot of costs, I think, you can imagine associated with the with a recall. Well, first is identifying the products. As Nate pointed out, FDA wants to know what the product is, where it is located, and how much of it is out there. And that sounds pretty easy, but that's probably one of the more difficult situations, is trying to isolate which particular lots are impacted, what the lot numbers are, where they've been shipped, and where are they right now. So then we also have, costs of storage and destruction, communication costs, staffing, inspection and testing, replacement products, refunds to customers, business interruption, and any rehab expenses. Sometimes people try to relabel things if possible. That's very difficult to do because of the short shelf life or the use life on these products. And the most intangible situation, but which is one of the highest costs, is the lost goodwill that's associated with a recall because of the press that's involved. So we need to be prepared, and it's really important to be prepared. So when somebody walks into your office and they just said, "Oh, we got a little problem. I got to talk to you," you really need to have someone in your companies that really uh, is ready to act when it happens. And we try to get people prepared for that before they occur, so that it's not. We try to manage this crisis as as best we can, so that we can deal with the issues. As Nate said, talking to the regulators, they want to make sure that we're organized. We can answer their questions. We've done some sort of health hazard or safety assessment, and we can identify where those products are. And so that's hopefully you'll get some of that from today's webinar. Of course, I tell people, you see the best in people and the worst in people in times of crisis. So we need everybody to relax and to understand that we can get through this, and that we need just to keep our head and wits about us, and we need to be able to think clearly and rationally. We need to fully investigate the situation before drawing conclusions and embarking on a plan. We need to really understand what the nature of the issue is, what the scope of the problem is, how extensive it might be. But once we do that, then we have to embark on that plan, and we have to be pretty decisive about doing it. You can't put these things off for an extended period of time. If there is a problem, FDA expects people to address it and address it in a timely and a comprehensive manner. And we have to try to manage that situation very carefully, both in-house, both with our customers, with the press, as well as with the agency. Always be prepared. That's what the Boy Scout motto is, and we try to put a little bit of humor into these presentations too. So some of the survival tips, don't take risks or shortcuts. It's not. You're going to end up paying for it longer in the long. You're going to pay for it in the long run. We really need to make sure that we are comprehensive in its scope and that we act in a very conservative manner. We can't act impulsively. We really need to have a plan. We need to have someone who takes control of that situation and that is really managing the situation. Don't avoid people. I think we need to make sure that everybody is engaged and ask for help, and people need to pull together and get these and deal with the issues at hand. All right, it's not, the burden isn't shouldered on one person, and in order to get this done effectively and to communicate with the customers, we need to have an entire team, and we need to have that team focused and all on the same page when they're doing the communications with respect to a recall. And don't lose your spirit. I mean, most of the times we can get through these things, and we just have to work through it, and we need to be able to move on from the particular instance, get through it, and then move on to the other business at hand. So first, we really need to figure out if we have a problem. And how do we do that? We take a look at whether or not you've conducted an investigation. How do we know how it was reported? Did someone look into it? Do we have confidence in that investigation? Was the scope of the investigation broad enough to identify the issues and potentially the root cause of those issues? It's really important to understand why something may or may not have occurred. And again, determining which products or units could have been affected and how we define that is very important, and very important to articulate the scope or the limits of that to try to limit the potential impact on the number of units that are out of your ownership and control. So we try to make sure that we do a really good job understanding where the issue had occurred, when it occurred, and trying to be conservative, drawing lines around it to make sure that we don't let products out into the marketplace that either are adulterated or misbranded. Trying to look at where they manufactured on a particular shift and things of that sort, and what are the potential issues associated with a particular lot. Then we have to figure out, does this problem warrant a recall? how is it classified? What's the nature of the issue? Is it something that is just a start recovery or a market withdrawal? Or is it something that we really do have to recall? And people have to take that decision very seriously, and they have to be very judicious in those decisions, and it has to be very well structured. So we have to make sure that we have sufficient information, and we have to think about everything in terms of the potential impact on public health. And so when there's a potential impact on public health, we have to, the expectation is that we're going to do the right thing to make sure that the public isn't exposed to serious health consequences as a result of exposure to the product. So we have to act fast, we have to have sufficient information, and we have to be definitive in terms of the types of actions that we're going to take. And to the point of, sometimes if you've got a question, do we just stop shipment in the warehouse right now? Until we figure this out, we say we're going to just put everything on hold until we figure it out. And, we might, interrupt the supply for a day or two, but we take a decisive action and we don't let anything else outside of our facility until we make sure that we know what's going on and we have a determination as to what potential, what's the potential of the issue and the scope of the issue with respect to specific lots that have been that are likely to go into the marketplace. Developing a plan, as I said, it's important to have a plan in place and to make sure that we buy into that plan and it's a sound and a rational plan. Making sure that everybody around on the recall team has the opportunity to have input and to say their piece about what's going on, and then someone has to take responsibility for the company as to where they're going to move forward with this and how they're going to, what is the appropriate course of action. Again, as I've said a number of occasions, consumer safety is of paramount importance, and we want to make sure that we do the right thing. We have to decide whether a recall, correction, market withdrawal, stock recovery is the right course of action, the latter two being a little bit more limited in their applicability depending on the nature of the potential issue, and we have to be prepared with appropriate communications. And so it's kind of nice to have a template ready to roll from a recall notice and how we're going to communicate that recall to our customers, how it's going to get there via fax or electronic mail with return receipts, and have that language ready to roll. And then we have to decide, who's going to negotiate with the FDA, whether or not to communicate with FDA, and over what, and what are the real big-ticket issues that we need to deal with. As Nate said, reporting issues to FDA is voluntary. We think it's a good idea, but it's not necessary to wait to take appropriate action if it's the right action before you notify FDA. So a lot of times we'll decide that we're going to recall the product. We initiate the product recall. We've decided these are the scopes of the issues, and then we start sending out the recall communications, and we also then notify the FDA, because it shows that you've taken responsibility, you understand what the actions are, and you're moving forward in a timely and consistent manner. We have to make sure we know who's in charge. Is it someone both in-house or outside third party? It's important. We have to continue to make sure that this plan moves ahead. So we've got, as Nate said, that we have the initial recall. We have to communicate with people that recontact people that we might not have been able to have a communication with originally, and sometimes if they didn't read their email, you might want to call them too, just so that we know that people have gotten the message. And then we have to make sure that we do a follow-up, and then at some point we want to terminate that. So we want to make sure that that we have all those pieces in place as the recall is moving forward. And we really recommend that you conduct a mock recall so that we're ready, that we know where your procedures are, and that we're ready to implement any possible changes, because when it happens, we'll be prepared. And it's just a lot easier if we're prepared in advance than having to do this when people are a little bit more excited and a little bit more in a crisis mode. We also want to make sure that we have appropriate corrective and preventative actions to prevent these from recurring in the future. So, once we have the recall down on one side, we're also looking at what can we do to correct that problem. Is there any reconditioning, and what is the cost of reconditioning if we can do so? Must it be destroyed? All of the lots, some of the lots, and things of that sort. And then again, our corrective action plan from preventing things from recurring in the future is very, very important. Dealing with FDA, we'd like to notify FDA regarding our plans. Depends on the circumstances, of course. We also want to make sure that we've addressed issues that have come up during any inspections, that have been any, where there's a warning letter or there's been a history of violative products and recalls. Likely, you're going to get a visit from FDA after you have a recall, so we want to make sure that that our ducks in a row and that we know how to deal with the FDA once they walk through the door. Again, we've got to work with the FDA on a regular basis, and so we want to make sure that they don't look upon us as the bad actors, that we, have control over our processes and operations, and that we are doing things that demonstrate our responsibility as a manufacturer of foodstuffs for the consuming public, whether that be in the U.S. or abroad. Again, what can you negotiate with FDA, whether or not it is a recall, market withdrawal, correction, stock recovery, the classification and the depth, the need for public warnings and things like that, as well as the extent of the effectiveness checks. Well, it's, we put these up as potential areas of negotiation. For the most part, FDA doesn't really negotiate too much with you, so we try to provide them with information right up front that demonstrates our responsiveness and and the basis on which we're taking particular actions with respect to a particular product. Communications, we try to offer our own versions of the recall letters as well as any press releases, because that we tend to spin them at least in a light that's a little bit more favorable to us as opposed to what the FDA is going to do. So that's pretty important. When to terminate the recall is also very important. The disposition of the product, 99% of the products end up getting destroyed or re-exported. So certainly something that we need to think about. Of course, FDA is likely to come in and do a follow-up inspection to see what happened and the scope of the investigation, and as well as any other corrective action plan. And if there's been a history of violations and things of that sort, we might expect to have FDA take further enforcement action against the company. Hopefully that doesn't occur, but these are certainly a possibility that people have to understand and appreciate. So I just want to end on this little war story note. It always happens on a Friday evening or a holiday weekend. Just when we're ready to go home, somebody walks into your office and say, "Oh, we have a little problem," or "I just got a call," or something. We found something growing in a sample that was in our shelves or something like that, or a customer called and said there's a problem. So we have to be prepared to deal with this and deal with this in a timely manner. So that's the nature of the beast, and so we just have to roll with that. So make sure you have an up-to-date contact list, and make sure that everybody just knows that they have to be available, and it may involve changing your plans for a little bit, but that happens. We've had situations with dietary supplements adulterated with inactive ingredients that have been issues. We've had a lot of microbial contamination with respect to imported smoked fish. We've had a beer, actually, adulterated with foreign objects in there, and microbial growth. The water system that was used to brew the beer wasn't well designed and well thought. There was a dead leg in there, and some of that water just happened to go into the brewing process, and they found some things in the in some bottles of beer that I don't know how they got there, but they got there, and I don't know how they didn't get caught, but they were certainly released to the public. Allergens and nuts and, with undeclared allergens, a lot of labeling issues, as you recall from the first situation that I put up, that a lot of those things occur. So we have to try to make sure that we know what's in our products. We know that the labeling is correct. We have controls over the manufacturing process and the labeling process to make sure that we don't have any mix-ups. And then we don't change suppliers. That's where a lot of issues come up, is that that there are changes in suppliers and things like that. Lastly, I've had food companies that had, their jars cracking or breaking during the manufacturing process, and we see something that has happened in the course of manufacturing where the caps there was too much torque put on the caps, and those broke. We had nuts and bolts and that have come up in situations, and a metal detector didn't work, and we've had pesticides, as Nate said, pesticides, minor amounts of pesticides, but they fall outside the appropriate limits or the appropriate exposure in a particular food, then we end up having to recall those types of things too. So, well, that's all I have to say at this point. I'm going to turn it over to Catherine to talk a little bit about what goes on in Canada.
Catherine,
Thanks so much.
This is Mike. Catherine, before you start out in the next presentation, let me make one other announcement. I indicated at the start that there would be 2 times during the program that I would have to announce CLE codes for the people on the line from New York, New Jersey, and Kansas. So this is the first of those 2. The code is 4 T as in Thomas, G, G. And as noted, there will be a second one announced. Please write down the codes and follow the instructions on the housekeeping tips in the materials section on your screen. Sorry for the interruption. Catherine, take it away.
Great. Thanks very much. So we'll turn this to a look north of the border at this point in time. 3 points that my colleague Bob and I will be covering as we discuss the landscape in Canada. First, to provide an overview of the legislation that governs food recalls in Canada. Secondly, a look at the best practice and protocols that are available to be followed, as well as resources to turn to when dealing with a recall. And finally, a discussion of the necessary disaster plan and checklists, how to actually manage the recalls when they occur on the ground. So to start with the legislation and the framework in which we're operating, there are 4 pieces of legislation that I want to run through from a top level. The Canadian Food Inspection Agency Act is the first, which establishes the CFIA, the inspection branch of Health Canada that oversees food safety and are the folks on the ground enforcing the legislation in this case. Secondly, the Food and Drugs Act. This is the primary statute in Canada at a federal level governing food standards, food labeling, and food safety. The third piece of legislation is the Safe Food for Canadians Act. This is a relatively new piece of legislation, just past its first anniversary since it received royal assent. It's more recent legislation, and it gives more teeth than the Food and Drugs Act once did with respect to food safety issues and with respect to recalls. And then finally, talk a little bit about the Health Protection and Promotion Act, which is provincial legislation, as an example of one province where there is additional legislation to worry about, not only at the federal level, but also at the provincial level, and to some extent it governs as well how to handle things at the municipal level. So to start with, the prohibition against selling harmful food. This is found in the Federal Food and Drugs Act and prohibits the selling of food that has in it any harmful substance, is unfit for human consumption, basically is something that shouldn't be on the shelf, is adulterated, or manufactured, prepared, preserved, packaged, or stored under unsanitary conditions. That's the general prohibition. Under the Canadian Food Inspection Agency Act, the CFIA has the power to require a recall where food is contrary to the Act. The Safe Food for Canadians Act adds a little more teeth to the recall power mentioned in the previous slide, where it is prohibited to sell the food and it has been subject to the order if the company is not following an order of the CFIA. And we'll talk a little later on about voluntary versus ordered recalls. But in the case where there has been an order and a company is not following that order, the Safe Food for Canadians Act gives additional powers for the minister to jump in at this point to disclose information without the consent of the party who would otherwise would have conducted the recall, to do what is necessary in essence to identify or respond to the risk of human injury or health, or to actually implement the recall. On a provincial level, we have additional legislation in certain jurisdictions. The Health Protection and Promotion Act of Ontario is what we're focusing on for today. This gives the power for the minister to publish guidelines for the provision of mandatory health programs, as well as services, and every board of health shall comply with the published guidelines. The boards of health are quite typically the municipal boards of health. And as part of this mandate, there are Ontario Public Health standards that are published to establish those various programs, as well as topic-specific protocols, including recalls. There are 3 protocols I'd like to touch on today. Again, that's covering, we've just covered is the legislative framework. Then we have the best practices and protocols. The 3 that we'll be talking about, 2 from Ontario and 1 at the federal level, and I'll skip through to that now. The first is the Ontario Food Safety Protocol. The purpose for this protocol is to help provide direction to the municipal boards of health on the delivery of comprehensive food safety programs. Some of the topics include surveillance and inspection of food premises, as well as being armed and prepared for timely responses to potential risks to human health or safety, including reports of foodborne illnesses or outbreaks, unsafe food handling, or other food-related issues that might affect food safety. The protocol, the second protocol, this is again an Ontario protocol, deals with the multi-jurisdictional response, how the federal, provincial, and municipal health and food and safety authorities will manage responses to foodborne hazards and illness outbreaks in the province. The next slide continues this to set out the purpose is really to provide key guidelines, key principles, and operating procedures for identification of and responding to for foodborne hazards and illness outbreaks in the province. Part of its purpose is to enhance the collaboration and coordination among these various levels, the federal, provincial, municipal, to establish lines of communication and information sharing among those various levels, and improve efficiency and effectiveness of response in order to protect the health of Ontarians. As you can imagine, if you're in a situation where you have multiple levels of regulators to deal with, having this kind of protocol to help define those boundaries is really essential. Moving forward to the disaster plan guide and checklist, again, we've got a few different resources on which to rely to help to, whether it be to look at in terms of defining your own internal protocols, but also to recognize what the regulatory authorities expect. And in this case, we're drawing from documentation from the CFIA, from the federal authority, for these next points. So the overall framework, the Area Operations Framework for Food Safety Investigation and Response, this is to describe the CFIA's overall approach to food safety investigations and the response. It describes the governance roles and responsibility of the various CFIA branches. In the context of a food recall, you'll primarily be dealing with the operations branch. That's where in the Office of Food Safety Recall, that first bullet. Of course, behind the scenes, there's also the policy and program branch, and they are going to be involved particularly with respect to determining upfront the protocols and procedures that need to be followed throughout the actual operation of the recall, as well as what corrective action might need to be taken. The other branches that could be involved, depending on the nature of the recall, the scope, and the health hazard that's being addressed, include the science branch, the public affairs branch, and of course the lawyers, legal services there to assist the CFIA officials. As I mentioned earlier in the presentation, there are two types of recall in Canada, not unlike the U.S. There's both the voluntary and mandatory recalls. The voluntary recall is still where, I think as in the United States, this is still what you will typically see. This is initiated by the company that is either selling, manufacturing, or distributing the product. Mandatory recalls, provided the provision for this earlier in the slide deck, where a minister can jump in to actually order a recall. This is unusual, but can occur if the company is unwilling or unable to implement the recall itself. And then also, as previously mentioned, there is even further power now under the most recent legislation to almost step in to effectively start disseminating information and move the recall along as a further step in that process. Again, like the FDA, Health Canada through the CFIA has 3 different classes of recalls, and again, very similar to the United States. They are classified relative to the degree of health risk that's presented by the product in question. In Class 1, there's a reasonable probability of serious adverse health consequences or death. Under Class 2, it's the potential for temporary adverse health consequences, or where the possibility or the probability of a serious adverse health consequence is remote. And Class 3, where there is not likely to cause any adverse health consequences. So again, lining up very similarly to what's already been discussed in the context of the FDA. I'd like to take a few minutes now to walk through essentially a flow charts that walk us through the course of a food recall in Canada. I'm not going to go into a lot of depth because of time, but this should provide a bit of a framework in terms of how the regulators and how companies will approach the issues. We start off with the triggering event. This may be a company-initiated issue. Again, it's the pop into the office to say we've got a problem. We recognize that there's something that needs to be addressed. This will lead to the food safety investigation. What are we looking at? Do we have an issue that's going to require further action? What is the situation being faced by consumers, retailers? Where is the problem occurring, and what needs to be done about it? Still considering the food safety investigation, we determine whether or not there is a hazard. Investigate what that root cause of the hazard might be, and identify the products that are subject to this potential hazard. Part of this is determining if the products are in the marketplace, and if there are additional products in the marketplace beyond what might have been first detected that could also bear the problem. We then move to the determination. Do we have a possible health risk or violation of statute which could be something like a labeling issue. If we have a potential health risk, we've got a food safety issue. If you don't, then the issue may end there. But the next slide is going to continue us forward, assuming that there is a food safety issue, meaning either a health risk or a other violation of the Food and Drugs Act, the food legislation in Canada. We look at the health risk analysis then to determine towards the left, do we have a health risk or do we have a non-health risk? And it is important to note, I think, that in Canada, a non-health risk, including misleading representations, quality issues, mislabeling, could still lead to a recall. Though if you follow the chain on the right, you'll see that it's likely to refer to the Class 3 recall, the lowest of the three classes, but could still end up in a recall situation. If we follow the tree to the left, we're looking at health risk situations where we have physical, chemical, biological, or allergen issues that are in the product that are presumably at this point in the market. At this point, it's a review of the risk management options and strategies to determine what the hazard is and how the recall needs to be implemented as a Class 1, Class 2, Class 3, again, as in the U.S., or if there are other options in this particular case. We go through implementation, and I'm not going to do a lot of repetition here because I know that we've discussed it in some respects in the United States, and I know my colleague's going to pick up a little bit of discussion about the checklists and how to manage things. But again, this slide for your future reference provides some handy checklists in terms of what to consider, what you'll need to coordinate with the CFIA, as well as what to manage internally. Of course, verification. Was the recall effective? Have the products been returned, controlled? Has the recall been effective? And finally, the follow-up. What is going to happen to the product? Again, likely destruction, control of any product that's still in warehouse, and future corrective action to ensure that this won't occur again. And with that, I'll turn it over to my colleague, Bob.
Well, thank you, Catherine. As Brian said in my introduction, I spent a number of years in-house for a company that had a group of food processing plants, and during that time, we experienced a very significant recall that made it into the House of Commons. It was on the front page of the newspaper for a number of days across the country, created some stir at the border between USDA and CFIA, and was just a mess to deal with. So my talk will be fairly brief, but I'd like to just talk about some of the things that I think we can do to prevent them and to deal with them in a timely fashion when a recall does arise. The first point that I would raise is quality assurance in advance, and this is quite trite, but the most effective way to deal with a recall is not to have one. If you haven't had the misfortune to be involved in a substantive recall, it's hard to estimate its impact. It strains your resources, puts people under a great deal of pressure and stress, and so if we can avoid it, obviously we do. The regulators' standards are not, that is not the standard. They're a threshold. It's what we need to do to ensure that the safe product is introduced into the marketplace, and that is our primary obligation as a producer. So if I could go to the next slide on what management can do to prevent recalls. First of all, it starts with food safety research, being ahead of the curve and industry standards in what we introduce into our plants. This money spent early and time spent early reaps dividends later on. If we're at the top of our game, we just minimize those risks. And second point that I would raise is every corporation has its own culture, and I think it's really important if you're in the food business, the business I know, to promote and instill a food safety culture. Certainly you get the best QA people you can, you employ outside consultants when need be, but it needs to work down the line. The employees that are on the floor need to understand that food safety and people safety are their two priorities, and production needs to follow, obviously, but without food safety, it's sort of not a very worthwhile endeavor. And I think for management, the difficulty is that the recalls happen typically at the plant level, and it's a step removed, and it's hard to you've introduced got your plans in place, you've hired the best people you can, something comes up that you don't expect, and I think it's important to be looking for things that are unusual. If you have labor unrest, if you've got union issues, that's a really classic example of that. Equipment breakdowns or changeovers that you're introducing new systems to check your product, and that you really need to be vigilant. Or personnel changes in the plant. You get a changing of the guard, and there can be a period of time in which there can be some things fall through the cracks, and that's I think it's really important for management to look at that. And certainly keeping records, and this has been touched on before, can't overemphasize its importance. Keep records of what you've done, make sure they're accessible. If a recall hits, they're going to be very, very important. So if we can go to the next slide, having a recall plan, it's very fast. This has all been mentioned. There will be havoc and confusion. Staff are going to be worked off their feet, and there's a real need to have a plan in place to try to minimize the effects of the recall, and to satisfy the regulator that you have things at hand, and you're dealing with it in an appropriate fashion. So to do that, and going to the next slide, it is developing your team in advance, and I think it's really there are three components to it, as I've outlined. First of all, management needs to know in advance who is going to be standing forward. If it's going before the press, who is that person going to be? Who is taking the lead? And so they're accessible and available to deal with things over what could be an extended period of time. And secondly, I really recommend developing a relationship with a public relations firm. There are a lot of different ways to present something, and these folks are very good at minimizing the hurtfulness and putting the right spin on it, to use that word, presenting it in the most positive light. Each step you take in a recall, you've got insurance issues to consider. There's always the risk and the potential of a class action lawsuit out there. There are lawyers just waiting for this stuff. So you need to be as well organized as you can going in to try to make the best decisions that you can. And the third component of that, of course, is the legal team. There are difficult decisions to be made early. Should there be a voluntary recall? How are we going to respond to this? Are we going to push back at all? Are we simply going to cooperate? These are not the immediate reaction is yes. That's not necessarily always the right answer, and I think that it's important for a company to know who they can go to try to get answers in a hurry. As one of my colleagues earlier said, it always seems to happen at the wrong time on the start of the July long weekend, and so it's a matter of being able to access people when you need them. And the next slide on record keeping, the regulator is going to, of course, and properly be requiring records and records in a hurry. If it's a large processing plant that's putting out a lot of product, there's a lot of work to be done to gather those records up. The sooner it can be done, the sooner the recall will be quantified and it'll get out of the media. And so it's really important to have those records in place and have them accessible, understand how to get the material back to the regulator as quickly as possible. So moving to the next slide, if you have a recall that is with product in the hands of a large number of consumers, the volume of communication from them is just startling. Lots of people who should be and lots of people who shouldn't. And you need to somehow manage that flow. And I think the things that I've found most effective, one is to establish a dedicated website that strictly deals with this recall. And that website will talk about some safety concerns. It will provide some questions and answers. It will give instructions on what to do with recalled product, and likely provide a phone number to, if you have a concern, giving people somewhere to call. And that's where the call center comes in. I think that these folks are not highly skilled in this field individuals. It's simply a call center. They need to be scripted, but they will take down basic information and find out what product was purchased, where it was purchased, whether a person is sick, and the number of people involved associated with that particular purchase. So that's the first level. And then I think the best way to manage it is to divide it into different buckets. If it's simply people wanting refunds for purchased product, that's simple. There are some that will have incorporated the recalled product into other products. It gets a little bit more complicated there, but still fairly manageable. And then you get the people who are alleging sickness, and those need to be dealt with in a separate fashion. There are lots of there are companies out there that specialize in this catastrophe control, disaster control, and if provided with a list of people you want them to contact, they will call back with a detailed questionnaire, and you can really get a sense of what you're dealing with and have it all documented early. Fairly early on, if there's a class action coming, the class action guys will try to stop that, but they may not be successful in doing that. Turning to the next slide, of course, in a recall, you're hand in glove with your insurer. You may have recall coverage, you may not. Even if you don't have recall coverage, you may have coverage that applies to part of the issue that you're facing. You need to understand what you have. Again, I mentioned it earlier. there is the prospect of a class action. If it's substantive, it's likely to come. You need to keep that in the back of your mind. And while your insurer may well be covering the risk, it's probably prudent to have shadow counsel on your own. Your insurer and yourself have mutual self-interest to a point, but I think it's prudent for a company to also look at whether they want to have someone looking over what the insurers council are doing to make sure that it really protects the company's interests. The next point is the recall plan and dealing with the suppliers. Of course, in a recall, you have a series of very important folks, and your suppliers is one of them. The counsel of prudence and perfection is to have gone through your supply contracts going in so that if you can negotiate into those contracts a right to suspend ordering product, if you can't produce that product, you're ahead of the game. And you really want to be released from those obligations. If you're in an extended recall and it's dramatic, you could have a license suspension. You could simply be unable to produce for a while, and what you don't want is product coming through the door that you have to throw away because you can't deal with it. So moving to the next slide. The next and perhaps most important group are your customers. If you're selling to retailers, you want to maintain that trust. You want them to know that you've got things in hand, that this is a one-off. It's not your company philosophy or business. It's just something that happened. And for them, they're simply wanting to answer to their customers. So they will want to make sure that they can offload the people who are bringing Costco off the hook, and that they can offload them to you. That those people have a mechanism to have their problem dealt with, so that again their customers feel that they've been well treated by the retailer, and that goes back to the call center website information that will all be provided, so that folks feel that they have a way to. There's nothing worse than phoning and having a busy signal or saying, well, the company just didn't respond. You can't have that as your response. The next point that I would raise is your employees. The employees at the plant level are going to face just tremendous strain, and if it's a larger company, you really can recommend bringing some other folks in from other locations. You can't have too many boots on the floor. There's a lot of work to be done, and the employees will really be, and this was touched on a number of times earlier, but they're looking to management for leadership to give them the strength to work hard, get it done, and face the difficulties. No one wants to be dealing with a scenario, especially if a number of people are getting ill, and it's newsworthy. You've got to show leadership in the face of that. And finally, the last point that I would raise is to say that this too shall pass. We had a recall in Canada. I had a company called McCain's, and several people died, and I remember speaking to one of the fellows that was directly involved in that, and that's the first thing that he'd said to me. At the time, it seems like there's no end to it, but with an organized plan going in and some strong will, you do see your way to the other end, and the sun gets up again. So anyway, that's all that I have. I'll pass it back.
Thank you, Bob. Here's that second CLE code for people who are waiting on that. The code is A as in Apple, N as in Nancy, W2. That's the second of the two codes. We're now going to move into a Q&A session. I have received a number of questions by email. that I'm happy to tee up. Others may have received some as well that I haven't seen, and it's certainly I'm encouraging people, if you have other questions that you haven't submitted into the queue, please go ahead and do it, and we will address them to the extent we have time. The first question is specifically focused on one of the presentations. Nate, this one is for you. It relates to your comments about the reportable food registry, and in particular, the question was, why is infant formula carved out? Can you comment on that?
Sure, absolutely. That's a great question, and I think a logical question, as one would think that infant formula is certainly very important as well in terms of safety. And the answer is that the reason that infant formula was excluded from the reportable food registry, or I should say from the legislation that initiated the reportable food registry, is that there were already requirements in place that required notification to FDA for products involving, for infant formula, excuse me. Those requirements had already been in place, and there are separate mechanisms, although they are similar, and in almost all instances require notification to FDA within 24 hours, but the mechanism is not through the reportable food registry, but direct follow-up with the folks at FDA who deal with infant formula. So good question.
Great. The next question that I have is phrased in terms of the FDA, but I think it's probably equally applicable in Canada. So I would throw it out for comments by any of our speakers, and that is simply, how quickly does FDA or the Canadian regulators need to be notified in a recall situation? Comments?
Sure, I'll take that one first, Mike. I think you have to scope out the issue first, and if it's a significant public health hazard, I would certainly not delay taking the appropriate action first in terms of quarantining any material that's in-house, stop shipping things in the warehouse, and notifying customers immediately, and then contacting the FDA right after that. So if it's a significant health concern, we need to do everything that we can right away to limit the exposure to that particular problem. Once you have a good sense of what's going on, the FDA is going to ask you those questions that, from our perspective, what's the product, what's the nature of the issue, and where is it? You need to be prepared to have that. So you need to have that information or be working on that information when you contact FDA. But, we usually, between 24 and 48 hours, that's kind of where we are, if not sooner.
How about on the Canadian side? Catherine or Bob, any thoughts on this one?
Sure, it's Kathy. I can step in here. Not dissimilarly, I mean, probably the worst thing you can have happen, or one of the worst things, is to have the CFIA find out about it through some other source. So there is a bit of a balancing that needs to be done. You need to have done your internal investigation to know what it is that you're facing, to be able to contact the regulator with that information. But particularly if there's a significant health risk that's being faced, then the key will be to notify the regulator as quickly as possible. But again, it is going to be a 24 to 48 hour kind of turnaround, no doubt about it, and faster if you feel that there's a significant health risk involved.
Yeah, unfortunately, there's no one specific answer. You have to evaluate the situations. I would rather err on the side of notifying than not.
And for Canada, the same. I agree.
Yeah, I would agree with that. Yeah.
Okay. The next question relates to press releases and whether or not FDA or the Canadian authorities typically require that a press release be issued. I want to take a swing at that one?
Sure, I'll do that. The answer is they're not always required, but generally it will depend on the severity or significance of the food of the potential safety risk involved, and oftentimes there is concern, especially from smaller manufacturers. Well, is this going to be required to be nationwide if it was distributed only within a certain portion of the country or that sort of thing? And the answer is, in all likelihood, it's going to be made available on FDA's website. FDA is going to try and publicize it as much as possible for the obvious potential consumer risks. And generally, we advise, if you don't issue a press release, there's a possibility that FDA might. And it's best if you can control the wording and the language of the press release. So we generally would advise, let's put something together. Let's have it be in language that we are comfortable with, and then we can share that with FDA if necessary.
Yeah, it's Bob. I would agree with that. In Canada, if whether they're requiring it or not, if they're going to put one on their website, you want to be involved in it and try to control the language of it. And so it's better to cooperate with that, whether it's a requirement or not.
This is my own follow-up question, I have to confess, and that is, what's your practice when you are working in recalls that affect both countries? Do you work to try and coordinate the press release in hopes of having the same language appear in both countries? How do you handle that?
The one is Bob. The one recall that I was involved in that was on both sides of the border. It really was not. The border was shut down to product very early on, and it didn't create. We were monitoring the U.S. regulators' reaction to it, but it was not. We really focused on Canada because it was not the big stir. There were a whole whack of them, and it was one little blip, and we really didn't need to focus south of the border. But that's because not a lot of product crossed the border.
In my experience,
go ahead. Yeah, sorry.
In my experience, where it is cross-border, it is beneficial to try and coordinate to the extent that you can. Certainly, the border for information flow is porous, if not for product flow. And so to have that consistent messaging for consumers, as well as for the regulators, in hopes that they will take a consistent approach to what's required for future follow-up, for what's required for future safety protocols. Quite often it's in your best interests to be looking to find a uniform response, and therefore early in the game to have both the Canadian and the U.S. officials on the same page.
And I was just going to say that if you notice from the presentations, the requirements are very similar in both countries. And I think that if you follow some pragmatic and practical advice by trying to be consistent with the things that come up, you'll be pretty well served in that situation.
And here is what, unfortunately, I think will be the last question we have time for because we're getting to the end of our slot, and I think it's a very good one. It has to do with the use of experts in recalls, food safety experts. Should a company hire a food safety expert to assist in the health hazard evaluation?
It's Bob. I would say yes.
We certainly do. We hire them for our clients. We have a cadre of people that we go to that can evaluate the potential exposure and provide our assessment as to what's the likelihood of risk of that exposure to consumers. Whether or not FDA ultimately accepts the opinions of our expert is another story, but it's nice to have a good starting place that provides a sound rationale for why we've taken a particular course of action.
And I would just echo this as Nate as well. I mean, sometimes it's nice, especially when you're in the heat of it or the thick of it, just to get a reality check from especially someone, let's say for a microbial contamination or something like that. Talk to someone who really knows the issues, has a lot of experience at the scientific level to really walk you through is this particular strain of particular concern? How does it affect? If there was some processing but not total processing, it really can be very helpful to talk to an expert who can be a little bit uninvolved in providing some advice. So I think it's a very, very helpful, and in many instances it will provide some additional credibility to FDA and show that you've done, done your homework on what the potential issues are.
All right. Well, I want to thank the speakers. We are at the end of our time period, our allotted time period. I guess my final comments would be, as you probably picked up from David and Bob's presentations in particular, the practical recommendations about how to deal with recalls in Canada and the United States are very similar. We've done our best not to repeat ourselves, and so we've allocated between us what those recommendations are, and hopefully you've come away from this with some good best practices and checklists. And what you probably picked up from the other presentations from Nate and Catherine is that the legal requirements are similar, but they're obviously not identical. And the key is understanding both so that in recalls with implications for both the United States and Canada, you can respond in a way that efficiently meets the requirements of both countries. This wraps up our program. We invite you to contact any of today's speakers if you have additional questions or if you'd like